So today again we are meeting for Tweaking Tuesdays, that is particularly focusing on contract practice, because contract practice and also it is having most of the things covered under contract administration also. That will be at level 2, although you will be administering what are all the things provided under the contract practice. So if you prepare the contract itself, that comes under the contract practice. But contract practice is also administering it, extension of knowledge, evaluation, and advising. But when you go to administering the contract, that means the existing contract you have with you, you will administer, you will apply it to the requirement of level 2. So that is the thing. Other than that, contract administration and contract practice are similar in nature. The main thing is that at contract practice, you should be able to advise at the level of making the contract itself or implementing certain contract provisions, amendments, those kind of things. So we have to see where we are actually heading from there after preparing the contract. So let us move with the question answer. The first one is from the principles of contract law. So we are primarily focusing on FIDIC, which is common in our area of practice like Middle East. But if you are using some other thing, you can comparatively understand what is the necessary thing to apply with respect to your own contract, because you are going to answer each and every question from your experience, your knowledge, and your understanding. Nothing more than that. So please always keep trying to relate it to your own experience. That is what important when you go for APC. So first question, a contractor on a red book contract claims for a significant additional payment. So what he is arguing that a letter of intent is issued before the formal contract was signed creates a separate binding contract for that scope. Advise the employer on the contractual and legal implications, specifically addressing the concept of certainty of terms. So anybody wants to try? Okay. So this is particularly about the letter of intent. Letter of intent is a letter informs the intention to proceed with contract in a future date. That means if at all the work required to be developed or the development is about to get into materialized, then the contractor will be the getting the job, but at the same time it allows some authority that will help the contractor to start some unimportant works in relation to the project, not the work itself. Because in UAE, particularly without having the contract and getting the building permit, we can't start the work at site. That is impossible. But you can prepare something off the site and by taking some arrangement kind of activities. That kind of authority to commence limited work, that's what the LOI going to give. But it's not merely, it's an agreement to agree. That means in future you are going to sign the contract. When you are signing the contract, automatically it supersedes the existing LOI. So it is not going to be there because it is already superseded. And when the LOI having certain words like the contract will follow, that means you are going to sign the contract at a later date. So you don't need to worry about the LOA at all. If at all the contractor is not getting signed, then you have only left with the LOA where some of the works are executed in related to the project. So those kind of things you can do based on certain allowable circumstances. But whenever you have the contract itself signed, then automatically the LOA becomes superseded and it has no value after signing the main contract. It is not a separate binding contract at all. It's just a temporary provision for your main contract. So that is the thing you have to give here. You can say how the contract is governed by four corner principles or certainty terms that making it as a binding agreement. So usually the letter of intent, what we are giving, it's not a contract. It is the just conveying the intention so that the contractor may have some liberty to prepare himself to commence the work, but not commencing the work outside. Okay. The next one is legislation. Your project is in a jurisdiction adopting FIDIC and is subject to local construction legislation regarding statutory payment periods. Advise the engineer on how to reconcile the FIDIC subclass 14.7 payment 56-day period with a local statutory requirement of for payment within 30 days. If your local law it enforces a 30 days period for payment of the interim payment to the contractor. So in that case, how you are going to advise the engineer particularly? Anybody wants to try attempt answering? Again silent. You have to try answering. That's why, because even though it's right or wrong, you have to speak up. Then only at the interview you will be able to speak at least. If you leave it with pause, that means you go blank. So it is not a good sign for the panel that either you are right or wrong or you are good to answer, or if at all it's not in your knowledge or area of practice, you can clearly mention some reasoning at least for that. So you have to start answering. But whenever you want to amend the contract provisions, you have to implement a particular conditions of contract which FIDIC allows you to amend the contracts. The 14.7 payment class you want to amend, which is by default it is 56 day. You can change it by implementing a 30 days. That can be again proportionately divided into reviewing and certifying, then release of payment. So that can be done by amending the contract. So again, it is specific to the requirement. So what you are doing is amending by changing the contract in the particular conditions of contract. The general conditions of contract remains untouched when you mention it's a FIDIC red book. Otherwise, if you are mentioning bespoke, then you are going to change the general conditions of contract because you don't need to worry about what is changed in the general conditions of contract. You can edit anywhere. That is called bespoke conditions of contract. If you are using the FIDIC in its original nature, you are allowed to amend any conditions by adding or deleting or changing a provision within the general conditions of contract by applying under the particular conditions of contract. So that's what you have to advise in detail. So current case law. A contractor cites a recent well-known court case. That means there was a court case of a different project. So regarding the concurrent delay particularly, because concurrent delay is not defined within the FIDIC. When you are referring to FIDIC Red Book 1999, there is no reference for concurrent delays. So you have to go by case, not the court case, your delay events. To support a major extension of time claim under 8.4, explain to the employer how the ruling impacts the assessment of the claim under the Red Book, including the principle of global claims. Because this is when they are particularly referring to the concurrent delay, that means it becomes global claim. It's not specific to the event, particular event. So then we are referring it as a global claim. That means we are combining them to understand the total impact on the project instead of addressing each and every event individually, like doing some window analysis, those kind of things, case by case or event by event. You want to identify who is culpable, whether compensatable or not. So those kind of things you will evaluate by the event. But if you are combining them to understand holistic approach, then it becomes global claims. Although global claims, it is combining together in civil law, particularly in Middle East, most of the countries, they are following civil law. That means you cannot refer to the different court case verdicts or judgments as your reference to the current case. That means in common law countries where you are allowed to use a judgment or verdict in favor of your argument, that is not the case within the Middle East that you can do that. So it is basically invalid in civil law countries. So you have to go by the book, what the law says, what the articles that allow you to interpret. So those kind of things only, or you can advise within the civil law countries. If you are in common law countries like India or UK, then yes, of course, you can refer to the court cases where you have clear verdict on particular similar nature of cases, that is mentioning about concurrent delay. You can use that, but still when you are applying, the legal terms are not important when you are go by the contract provisions. First, your contract that governs your obligations and responsibilities. Once, if it exceeds the permissible dispute resolutions methods that is listed or provided under your contract, then only you are moving forward to legal procedures. In that case only you are going to use these kind of references. Otherwise, it's not going to be applicable. So in that way, you can advise to the employer that it has to be considered event by event by analyzing clearly whether this concurrent delay is important or not. You can decide on your own based on your contract provisions. You don't need to worry about different references made by the contractor for other court cases. Okay. Let us move on to third party rights. Employer wants to issue the building's maintenance company with a collateral warranty, but the Red Book only references the main contract parties. Advise the employer on the legal necessity and contractual mechanism under the Red Book for granting third party rights. So, third party means the end users. Maybe the maintenance company, they just want to have the direct access to the warranties and guarantees for the future maintenance. Anybody wants to try?
Collateral warranty will provide the contractual. Uh,
Yes, go ahead. Whatever you consider.
the collateral warranty will provide the end users the contractual party. I mean, contractual. They can call for the maintenance. I mean,
Okay,
so that's essential. I mean, for the maintenance projects.
of course. But collateral warranty that can be given to the parties which are not contractually involved in the project. That means giving collateral warranty directly in the name of the maintenance company. So it is not in the original form of contract, but as we discussed already, if you want to implement certain things, you would better use the particular conditions of contract to amend that you are going to issue the contractor to execute collateral warranties in favor of the named third parties. That means you, for sure, you will know that there will be a maintenance company or a third party that is going to take control in future for the even during the defects notification period or even during the warranty periods. So that is what it is important. So no need to worry about all those things. But in order to implement certain provisions, so what we will do, we will amend the contract in the particular conditions of contract. Something like you can say assignments, like novation assignments. This assignment, it will give the named third party to get benefited from the collateral warranties. So you have to change the subclass 1.7 in the particular conditions of contract to allow this kind of provisions. That's what it is important. Okay, thank you for that. Let us move on to next question. Standard forms of main and subcontract. The employer has a complex design scope, is considering a FDIC yellow book over the red book. Advise the employer on the key contractual risk shift and the implications for the role of the engineer, because you have red and yellow book here. So you want to compare how the engineer's role will be when you are using red or yellow, or what is the risk transferred through either FDIC or yellow book. because particularly he is worried about the complex design. That is the risk we are discussing about. Anybody wants to try? Okay, again silent. So the allocation of design responsibility and risk. The red book, it is like primarily designed by the employer. So that's why the employer has the, and again the golden principles. That one it allows a limited amount of design responsibilities that can be transferred. So we can say like contractors design portion. So those kind of things has to be limited. But when it comes to yellow book, it shifts primary design risk to the contractor because it is plant and design build. So here design and build, it transfers the design risk to the contractor primarily. When you are administering like a employer-led design to reviewing and commenting on the contractor-led design, then it is going to be the engineer's role moves from being the key design certifier, what is there in the red book, to the one of reviewing the contractor's proposal for the compliance with the employer's requirement. So this fundamentally changes the nature of design related claims and variations. So it is going to be completely entirely different. The engineer's role, it's not going to be at the certifier level, but he is reviewing the proposals of the contractor for the compliance. He cannot give certain things under yellow book. So this is the case. Based on the thing, you have to see what is suitable to the particular requirement and advise the employer accordingly. Okay, let us move on to next one. The roles and responsibilities of parties. So here a dispute arises over the quality of a permanent work item. Advise the contractor on the exact procedure under the red book to challenge a direct instruction from the engineer to remove or replace the work, which the contractor believes is compliant. So that means he is considering the work executed, permanent work it is. So it is up to the required quality and it meets and compliant. In that case, how it can be challenged, because now the instruction being issued by the engineer to remove and replace the work. So how the contractor could challenge in this case? Anybody wants to try?
I think the engineer should notify to the contractor for the default of the works.
I didn't get what you were mentioning. Engineer, he has instructed that the work is not compliant. So he is asking to remove and replace the permanent work. It is already executed. But the contractor believes it is up to the specific, like a specification requirement or based on the drawings and specification provided to him. It is according to the client's requirement or contractual requirement. In that case, what is your advice to the contractor here? It's not to the engineer, because the engineer already issued the instruction. Now, when the instruction is in place, what will be further action the contractor could take?
Contractor has to submit the substantiations to prove that the works are in compliance with the required objectives.
Okay. So how you want to? Okay, you will provide it as a what? Will simply provide. Already you would have submitted work inspection request. So if the engineer didn't sign it as a complaint, he rejected the work. So what is your justification in that case as a contractor?
So the engineer is not satisfied with the works, then it has to be further escalate to dispute, I guess, because it has to do.
Yes, because it has to be
engineer determination or a dispute. It will
yes. So first you have to comply immediately. So
we have to submit
when the instruction of
submit the formally the substantiation for the compliance. And still, if things are not disagreed with the engineer, then has to go with the further for the engineer determination or the dispute resolution.
But you have to issue the notice as a contractor's claim. That is what it is important. Otherwise, it is not going to be valid. You cannot simply submit something. Already you received the instruction. Once you get the instruction, you have to comply as per class like 3.3 in the red book. instructions of the engineer, you have to comply. When you are complying, you have to remove the permanent work. Now you can't simply submit some documents or proof from the drawings and specification that is supporting your work executed is compliant. So first you have to give notice. As you mentioned, it has to be a contractor's claim, and you have to mention this work is compliant, and any removing and replacement would be a variation and as well as additional cost with or without EOT based on the time and cost impact. So that one you would be submitting at later stage, but you have to issue the notice. Then if the engineer is not answering to that or taking any action towards it within the reasonable time, then you may ask for the determination. Engineer may give his own determination by himself, or else you can ask. So once you get the determination, based on that you may go for, if because in the Middle East we don't have most of the projects having this dispute adjudication board, so automatically you have to go for other dispute resolution procedures which you have within your contractual procedures or provisions what you have. So this is the case. So you can't simply submit some documents through correspondence. That will delay the process. So you have to issue a contractor's claim notice. That is the first thing you can do. And you have to mention that you are proceeding with the removal and replacement. So you are reserving your contractual rights. That's what you have to do. Okay. Thank you.
Okay.
Let us move on to next one, assignment or novation. Under this, the employer intends to sell the project midway through construction and needs to transfer the main contract to the new owner. Advice on the correct contractual mechanisms, assignment versus novation. So what do you understand between either it's a assignment or a novation? So that understanding you have to utilize here in order to advise appropriateness of any specific procedure for the employer to transfer the main contract to the new owner. And the red book requirements, anything if you are aware of. So nobody wants to try. Okay. So first thing, like we all know, the novation only transfers both rights and the obligations. Not simple assignment. Assignment usually transfers of rights only. In that case, what we can do, assignment is insufficient for this kind of transfers. Novation, again, it becomes a tripartite agreement between the original employer, new employer, and the contractor. So that creates new contract between new employer and the contractor, extinguishing the old one. So that's what happening under this. But the red book subclass 1.7 assignment, again assignment is not applicable here. Still, what it says that neither party shall assign the whole or any part of the contract without the prior consent of the other party. Consent is often given in the PC for financing arrangements, but not typically for a full change of employer mid project. So that is not going to support. Again, assignment is only transfer of rights only. So it is not going to be useful. So therefore, you have to advise that this kind of novation agreement, tripartite novation agreement, should be in detail prepared between new employer, original employer, and the contractor. That clearly it has to extinguish the old one. Otherwise, that is going to be an extension. So you will have to refer the old contract, new contract, everything. It's not like that. It should completely extinguish the old one. So that is what it is important when you are advising for novation of the main contract in the midway. So next one, letters of intent. Again, already we have discussed about whether it is creating a separate contract, binding contract or not. Here, the employer insists on issuing a letter of intent to start site mobilization before the contract is signed. Advise the employer on the key risk and how to manage them contractually using a consent to spend approach. So anybody wants to try? You have any experience using the LOI, either as the contractor or employer? How was it used?
Hello.
Yes, please.
Yes, sir. Am I right? The letter
Yes,
of
please.
intent is basically that is not a binding contract. So in case the client wants to go through the letter of intent, so first of all, I will understand the client's requirements regarding of the time. So and I will explain the entire risk going through the letter of intent. If that is not binded and there the not entirely mention the payment mechanism of the dispute resolution process. So in such scenarios, that can create a dispute between the contractor and the employer. So I will advise to wait until the original contract has been signed, or to be commence work to establish the preliminary requirements at site. So this will be my advice, because as of my experience, here was one project where the client has been issued the letter of intent, and later on, no, client is not going to issue the binding agreement. So these are the type of risks. So I will advise to wait until the issuing or the signing the original agreement. So that's it, sir.
Okay, thank you for that. Yes, Mr. Moyo, you are about to start something. Would you please?
Hi, can you hear me?
Yes, yes.
Yes, okay. Yeah. If I was to advise the client in this case, the first thing I would make clear to the client is that one thing is there's no contractual status when it comes to letter of intent. That's one thing. So it may not be binding depending on the wording. So they have to have more robust wording in the document, and there's danger of not defining the scope properly. They may proceed, for example, the contractor may proceed with works beyond what is authorized. That's another issue. When it comes to insurance and liability gaps, it could be quite unclear. So it's quite difficult to know who bears the risk during this time when you're operating and doing some works under the letter of intent. And there's no such thing as no formal terms in terms of liquidated damages and completion dates. They may be there, but they may not be binding, and could be quite difficult to get enforced. It may make both parties a little bit hesitant in signing the contract. Things can become quite protracted. They can go on for a long time. Those are the dangers of that. My advice to the client is, if they insist on using it, make sure that you use proper legal advice to make sure that they have a way to get out of the contract when they need to. That's what I would advise to them. However, if it's executed properly, they may be able to carry on the works as early as they intend to. But just watch out for those drawbacks.
Yes, that is really valuable. When you extend to the consent to spend, you can include some of the terms such as setting a maximum expenditure cap, explicitly limits the scope of works which you want to go ahead with. When you are mentioning mobilization, means what are all the things you want to permit the contractor to go ahead, and again states a clear long stop date for the contract signing. There should not be delay in signing the contract. So that has to be, otherwise it has to be on hold until the contractor being signed. So you have to keep a long stop date, which is explicitly mentioning a clear date. And it expressly states that the LOA is not a contract for the whole of the works. So what is only the intended purpose of issuing the LOA should be clearly defined. So these are the things you have to take into consideration when the employer insists on going ahead with issuing this LOA. Otherwise, yes, of course, this is very ambiguities are present when you are issuing, particularly for a liquidated damages, uncertain terms for something like time at large. Yes. Mr. Dean?
Hi, Mr. Dinakaran. How are you?
Yes, please. I'm fine.
I have a small question about this. When we say consent to spend, which means what's the phrase that it means in LOI here?
That means you will be allowing or authorizing the contractor to spend something towards that can be payable by the employer. That means there will be, it's not only the intention, it further extends to certain limit of contractor preparations by spending towards the project.
Which means still we don't have a BOQ, so that whatever
No, BOQ would be there, but it is not signed. Already the BOQ would be there because when you receive the tender returns, already the contractor has submitted the BOQ. The BOQ is there, but it is not contractually signed. But that's what we have to mention here. So what are all the items you want to allow the contractor to go ahead with, and certain limits like the maximum expenditure cap or explicitly limiting the scope, which are the preliminary items you would like to allow the contractor to spend and claim within this before going into the contract. That's what we have to use when you are giving consent to spend. So it has to be for the some kind of mobilization. So it is all about the preliminaries, like providing something that is off-site somewhat. So it is not going to be directly involving activities in the site for the permanent works.
So if this spending cap exceed, then in that case,
no, it should not exceed. That's what if they are, they have to provide some reports on a weekly basis or a timely basis. You have to follow and control it. Otherwise, of course, it is going to be a risk. You know it very well. So we have to follow that and control it. That's why we are giving. So if it exceeds, automatically you will certify only that cap limit, and remaining would be certified after signing the contract. Nothing more than the cap will be certified until the main contract is being signed. Okay. Okay. Is it fine, or anybody wants to add something, or okay? Let us move on to next question. Performance security. The contractor has provided a performance bond as required by clause 4.2. Advise the employer on the key differences and legal implications between a demand bond and a default bond in the context of a breach by the contractor, because both are performance bonds, but a term that is used normally as a demand or a default. In our area, Middle East, we used to call this demand as a unconditional and default as a conditional bond. So I hope you get this.
Can I try?
Yes, please.
I would advise the client to understand the difference between the two. For example, if, an on-demand bond is where the employer or the client does not need to provide as much evidence for them to be able to call on the bond, whereas the default bond, you need to be able to provide enough justification, substantiation to actually call on the bond, that to say that the contractor has breached the performance of their, the execution of the works. So I advise the client to take the demand bond, because it will be easy for them to remedy the breach through calling on the bond whenever is required.
Yes. So that is clearly distinguishing the purpose and benefit. And yes, of course, we have to, if we are adding this as the requirement, we have to mention in the instruction to tenderers or in the particular conditions that it has to be specifically the demand bond, unconditional bond. Okay, thank you for that. So the next one is about insurances. The contractor's all risk insurance policy is about to expire, and the project is running late due to both employer and the contractor's delay. Advise the employer and the contractor on their respective obligations for extending the insurance cover under class 18. Okay, forget about class 18. It may be anything based on your own contract provisions. but it is relevant to the insurance. So what would you advise? How you would persuade them for extending the insurance cover? Because both of them, they have the culpable delays. Anybody wants to try? Okay, so this is particularly for the insurance that requires the contractor to maintain the insurance until the taking over certificate. So it's a contractual obligation for the contractor. So until or unless the taking over certificate has been issued, the contractor has to maintain. But when it comes to the employer point of view, he has to accept lost to be completed works. If the project is delayed, the contractor must extend core policy for any period that is extension due to an employer's attributable delay. So that automatically the contractor going to get issued extension of time award. Then the contractor is entitled to get the cost for the extension for this insurance period. So whatever is there in your contractual provisions under the preliminaries, like you have how much amount it is there for the period as per the contractual duration, then you can apply the same thing for the extended period. But at the same time, the employer must be vigilant in demanding proof of the extended insurance, because without which you can't continue. So that's what when you are going for the interim payments, primarily you will be getting all the contractual requirements from the contractor, and this will be there in your certification page, which are the things are there, what is the expiration date. That helps us to keep in track of which one is expiring when, and we need to proactively advise them to extend them. So once they extended, we have to amend this detail into our certification page so that it will be clear proof that there is extended insurance is available, without which it will be difficult for us to execute the project, because the core policy is the one that helps. If something goes wrong beyond our control, the complete replacement cost will be available from the core policy. That is, it is very important. So we have to make sure that it is extended without any delay. Okay. Yes, Mr.
Sir, I
Din.
have a question. Yes, sir. If there is the extended, for example, delay due to the employer, and also as an example, 6 months for the employers or the 3 months for the contractor, so then the premium will be divided between the both parties. Means what the contractor will bear the cost for the extension of the insurance. So this cost, the additional cost, will be divided into the both parties.
No, that means it is not like divided. The contractor has to bear the cost first, and then based on the EOT, when he is getting awarded, that time it will be a cost impact certified to him for the extension of time. The time he is getting awarded, for that the cost impact will be including the cost based on your preliminaries where the insurance are priced by the contractor. So that will be applied on the pro rata basis for the duration of extension. Then he will get paid by that in the cost impact, not directly taking some division into the cost of the insurance that he is paying as a premium to the insurance company. That is not the case. Is it clear or?
Yes, clear, sir.
I have a small question. Now,
Yes,
as for the contractor for car policy, it's fine. How, like in FIDICOS in clause 18, there is no mentioning about the employer's insurances, right?
No. It
Yeah.
is
So
not about
only the
that.
car. Yeah, only the car insurance.
Yes.
Okay.
Okay. Let us move on to next one. Advance payments. An advance payment is requested under class 14.2. Advise the employer on the purpose, the key security requirement, and the contractual process for recovery and repayment. Anybody wants to try?
Yeah, can I try?
Yes, please.
Yeah. Usually, an advance payment is an interest-free loan that an employer provides the contractor to start mobilization works and to get all the project begun. However, there are some contractual processes that should be required to protect the interest of the client as well as the contractor. Most of the time, there should be a security in terms of advance payment guarantee issued by a reputable bank of choice of the employer. For the same amount, the advance is being issued. So this bond will be available with the employer until the advance will be fully recovered from the contractor. So the recovery process will happen when the contractor is making his claim as interim payment applications, and while the engineer is certifying, he will recover the percentage that's described on the appendix to tender. Else, for the same percentage of the advance being paid. For example, if the advance is paid for 10%, then the recovery also will be at 10%. So when the project reaches the full contract price, then the advance also will be fully recovered. So this is how I will advise my employer for if he wants to give an advance payment to the contractor.
Yes, that is clear and concise. Anybody wants to add something here, or is it fine? Because usually you will have these things listed in the appendix to tender. So that will be there. Based on that, you would apply how the advance payment will be issued, and you will have the specimen of the advance payment guarantee, and then the recovery details will be there. You would apply those things with your interim payments, and finally when the whole of the project value is getting certified, that time it will be deducted for the 100% with respect to the work progress. Okay, let us move on to next question. Interim valuation and payment provisions. The contractor submits a payment application for materials delivered to site but not yet incorporated. Advise the engineer on the criteria that must be met under subclass 14.5 materials and plant for the works for these materials to be included in the valuation. So usually material on site. So how do you advise the engineer to include them in your? Anybody wants to try? Yes, Mr. Shifat. Yes, please.
Yeah. If the contract provisions allow for the material at site, then I will advise the client to the subcontractor to submit the vesting certificate. And substantiations for the materials. So accordingly, and based on the contract provision, it has to be added in the interim payments for the.
Okay, how would you do that? Practical implementation of.
Following the materials.
May I try, sir?
Yes, please.
Accordingly, if the subclause is available there, 14.5, the material and the plant to be certified. So there is required the list of material must be available in the contact data. Also, the contractor will submit the payment application. Also provide the entire material delivery document such as the evidence of material delivered at site, inspection request, and also if there is required any type of security bond, and within the 28 days, the engineer will certify it and it will release the payments by the employer.
Okay. Anything further? Yes, please.
Yeah, actually, I'm not sure about subclass number 14.5. I'm practicing my.
It's fine. You go by your practical experience, because this is I'm just giving, since FIDIC is the most common. That's why. So don't worry about that.
Yeah, I will advise to my client to about the material on-site and off-site. First, we need to check the position, what's stated in the position saying, which is the material listed in the appendix to tender. And so once contractor purchasing the material and they want to claim the material on site, first we need to check the baseline program. So accordingly, baseline program and material list also, then we check the contract position with how much they need to pay, whether 70% is from the overall from the material invoice or from the BOQ, from 70% is from the BOQ rate, which is lowest one. So based on that one, I will agree on the document, such as if material on site means kind of my material inspection report, delivery notes, and material insurance. If material on site means material insurance, material coverage will be under core and insurance of the work. If material off-site means there will be vesting certificate, material bond, material insurance will be there, and marine cargo insurance will be our. We need that. We need to check. So based on that one, I will include the payment application. The payment I will include the payment application, and accordingly, if work is done in the upcoming payment, I will adjust in the BOQ.
Okay, thank you. Anybody wants to add something? Any specific point to this? Okay, so it has been covered nicely. Only you can add that they must be protected against loss, damage, and deterioration. So it has to be seen how long the material going to be there, or how it is going to be utilized. So those are the things are necessary for keeping them on site or off site safely. Thank you for valuable inputs. Let us move on to next question. Retention. The contractor is approaching the issue of the taking over certificate and is expecting the release of the first half of the retention. Advise the employer on the circumstances under which the engineer may lawfully reduce the amount released under class 14.9 payment of retention money. So what are all the items you can reduce from it? That's what the main concept is. As per contractually, lawfully, what are all the things you can reduce from first half of the retention? For which items or which categories you can hold or reduce the retention release?
Mainly for the maintenance.
Yes. Okay, you can go ahead.
Yes. So the engineer mainly.
Yes.
Yes.
After issuance of the taking over certificate, if there is required to hold some amount from the contractor, so that is any type of defective work that is not completely or the snag list, the work is minor defect in the work, or another type of damages of the cost that has been incurred by the contractor. So these type of cost could be from the retention amount of the contractor.
Okay. Yes, please, Mr. Moya.
Okay. When it's about time to get the taking over certificate, one of the things you can hold, retain a proportion of the amount for is if there are any outstanding defects or any complete works, the site can still be taken over. But if there's no sufficient progress completely, if there's some progress which is still outstanding, while yes, the taking over certificate could be issued, that money can still be, that proportion may not be released, and we may have to retain, a reasonable amount, just proportion to that amount of work, for example, that still needs to be done. You could still, if the contractor has not submitted, let's say, S-bills, O&M manuals, and warranties, and some of these test certificates, you might not do that. And then when it comes to the taking over certificate, sometimes there could be section completion or something like that, where only a certain amount can just be released, maybe only half of the project has been taken over. Then I would advise the client to hold onto that sums of money for works not completed as well. If there are any things such as maybe outstanding claims, if they're still unresolved, let's say, all of those sort of things, maybe, of course, we should have recovered all the advance payments. But if there was such a thing, then some of that half may not be fully retained as well. Then again, if retention is being replaced, let's say, by retention bond, the engineer obviously will ensure that the bond is received and verified and everything. That's another situation as well. I will advise the client that no retention will be released in this case. And then again, if there's a retention bond, there wasn't any retention held anyway.
Thank you for that extension. Yes, Mr. Gautam, you want to add something? Or
as per my contract, there was a 2 category for retention release. First one is when the issuing the taking over certificate, we'll release the 40% of retention amount. Then, for example, 10% means that will be for something. Okay. Then after receiving the whole completion certificate, so then we'll release the remaining 10%. So once they issue the maintenance certificate after the DLP period, then after the DLP period only, during the final account, then we'll release the remaining retention amount.
Okay, so here what is our focus is only for when issuing the taking over certificate, what is released, under which what we can hold or reduce. That is the question. So if you want to add something to that
Yeah,
point.
if in the taking over during the taking over certificate, we have a list of a snag list. This much snag list is kind of the minor work, so we have to list and we make a estimate for the snag list and how much the amount for this one. So accordingly, we can hold some amount for the retention.
Okay, so thanks for that. So particularly what we can reduce at that point is we have to see the outstanding minor works or defects or any other pending things are there. Of course, we can reduce for that, but that should not be in a way that is hindrance to the taking over. So taking over should be happening. That means the project should be usable by the employer after taking over. That is the case. So it has to be minor. It can be done simultaneously or during the defects notification period. Then only we can allow the taking over certificate to be issued and make some adjustment or holding something or reducing something for that kind of things. And again, retention bond is also another provision, as Mr. Moyo mentioned in detail. Thanks for that. Let us move on to next question. Change procedures. The engineer verbally instructs a significant design alteration that will impact cost and time. The contractor executes the work but fails to give formal notice under class 13.3 variation procedure. Advise the quantity surveyor on how to proceed with valuation. Anybody wants to try? Because you are advising to the quantity surveyor to proceed with valuation, because it's only verbal instruction. And
shall I try?
Yes, please.
Okay, I understand this question only the client will provide only verbal instruction, then contractor will complete start the work during based on the verbal instruction. Am I right? I understand the question then.
Yes,
like
yes.
That. Yeah. So then if there is verbal instruction means we need to establish the change control procedure, which is what is the in my as I have experience to establish a change control procedure before provide any instruction from the client. First, the client will ask I am a consultant. Client will ask the consultant to provide a business proposal based on the drawing. So I will prepare the business proposal, which is what are the cost estimate for this additional work. The additional work based on the historical data and BOQ rate, available BOQ rate. Then I will request to the change request. Based on the change request, the client will decide whether this change request within the budget or exceeding the budget. If it is within the budget, client will provide a site instruction to consultant. Then the site instruction will be forwarded to the contractor. Then once receive the contractor site instruction within 14 days, contractor has to submit cost impact assessment and time impact assessment. Time impact assessment will evaluate the planning engineer. Cost impact assessment we have to evaluate as a quantity survey. We will evaluate. Then the cost impact assessment we evaluate based on the existing BOQ rate or any based on the first principle or any quotation related for the contractor has to attach the quotation minimum 3 quotation or supplier rate, everything. So based on our assessment, we do our independent assessment, then we forward to the client. Then client will decide the rate, the contractor's cost impact assessment rate. So once we receive the contractor cost impact rate is confirmed, then as a consultant, I will prepare the variation form. So once the variation form prepared, then I will forward to the contractor. Please check and accept it. Then if contractor accept, then I will at the same time client I will forward to the client for their acceptance. So once the variation is formalized, then the contract amount will be changed. So after
Thank
that, the
you.
contractor
Yeah,
can
that's
entitle
fine.
for the
Because this is implementing the change control procedure.
yeah.
When we look into the particular scenario here, yes, please, Mr. Moyo, you want to?
No, I was going to answer that question, and I was going
Yes,
to say,
please. Yes, please.
all right. So, I would advise the quantity surveyor that they should not really go ahead with the valuation until they have, received until the engineer confirms the variation in writing, because under, I think, clause 13.2, it has to be written, and verbal is not enough. So you'd ask for that confirmation, and obviously, if it was verbal, then within a reasonable time they have to follow up with the writing. So just request that this is completed, and once this is done, obviously we can go ahead and go for the otherwise failure to give notice weakens the contractor's entitlement. But if the employer has they found, obviously sometimes they can be fair and they understand that this was done, it was not done properly, it can still be paid. However, it weakens their
Yes.
point, of actually receiving any entitlement for the variation.
Yes. So we have to stress the contractor, the importance of the contractor's notice requirement under this. So that is very important. Thanks for clarifying with respect to the particular focus. Let us move on to next question, valuing change. A variation involves work not of a similar nature to any item in the bill of quantities. Advise the engineer on correct method for determining the new rate under the subclass 13.3 variation procedure and 13.4 valuation of variations. So here about fixing the rate, it is particularly for the new item which is having no similar item within the bill of quantities. So anybody wants to try? How would you construct a new rate or determine a new rate for the change?
If there is no rate available in the contract or the BOQ, the items are completely different than the BOQ items. So then, in such scenarios, I will prepare the bill of quantity list and I will obtain the amount as a quotation from the suppliers and subcontractors. On the other hand, I will prepare the rate breakdown of the each activity. I will complete the evaluations and provide cost breakdown and the entire evaluations to the engineer for such cases for this type of variation.
Okay,
This will be
thank
my
you.
advice.
Thank you. Anybody wants to add something? So it is clear cut. What is the procedure is there? You have to build a star rate from the scratch and agree or determine and issue to the contractor. Sometimes you may request the contractor to propose with substantiations, then evaluate it. Otherwise, you can do it on your own by the engineer and determine the new rate. Thank you. Let us move on to next one. Extent of time, EOT and claims. The contractor submits a concurrent delay claim where an employer risk event overlaps with a contractor risk event. Advise the employer on the correct approach to assessing EOT and loss and the expense under the class 8.4 and 20.1 because of time and cost impact. Anybody wants to try? Okay, usually when they are submitting it is, we have to see what is the EOT. It's not like directly applying the concurrent delay due to time related risk being allocated to the employer to protect the LDs. So here they are not entitled to recover loss and expense when it is concurrent. Usually we can go as per the industry practice referring to the SCL protocol. Those kind of things are there in the market. But what we have within our contract, usually they have to establish clearly employer's event. So employer's event, if they are requesting for EOT, they should demonstrate particularly addressing the employer's event, they should not do themselves combining the contractor's event. So that is the first thing we have to ask the contractor to submit, demonstrating the employer's risk event and the cost incurred. If the contractor's own risk event would have caused the same period of delay or financial loss non-recoverable against the employer, that will be subject to the specific concurrency that has to be dealt by the employer and the engineer during the certification of EOT, but not that won't allow the contractor not to demonstrate the employer's risk event. What is the cost or time impact from that? He has to demonstrate fully first the employer's risk event, then only he can claim for the concurrent things or try to combine those things at a later stage. Anybody wants to add or to discuss something particular to this? Okay. If not, let us move on to next question. Dispute avoidance and resolution. An engineer's determination under class 3.5 is disputed by the contractor. That means engineer, he has given his determination, but the contractor is objecting and disputing it. Advise the employer on the next mandatory step in the resolution process under class 20, claims, disputes and arbitration, and the strict timelines. Anything if you are aware of from your contract. If it is FIDIC, that is fine. Anybody wants to try?
Yes.
Please go ahead.
If the contractor has a dispute with the engineer's determination, then I would then the next thing will be based on the dispute clause number 20. We have to see whether there is an allowance for dispute adjudication board. If there is, we have to formally raise the notice to the dispute adjudication board to get resolve, raise the matter to the dispute adjudication board and get a verdict out of from them. Even if they are, usually that should be the verdict of the dispute adjudication board should come within, as per the default, it should be for I think 28 days. If still they have a dispute on the dispute adjudication board's verdict, then the notice of dissatisfaction should be issued from the contractor and also the employee. If employee is also having an issue, then that will go to the arbitration process.
Thank you. Anybody wants to add something?
I would like to advise to the client, first of all, the claims regarding of the claim. If the contractor has been refused to follow the determination and the employer has been faced any type of losses or damages, so there should be notified to the contractor regarding of the claim. On the other hand, to be followed the dispute resolution process that has been added in the contract, that is the dispute adjudication board. After that, go through the amicable settlement process. If the issue is not resolved, then to be go through the arbitration process also. So these process and procedure could actually should be followed to resolve the issue among the contractor and employer.
Thank you. Okay, so particularly for FIDIC Red Book based contracts, usually notice of dissatisfaction has been served within the 28 days, after which the determination it becomes final and binding if the contractor didn't serve the notice of dissatisfaction. If he served the NOD, then only within the next 42 days he can refer it to the DAB. And even after the DAB, as you have mentioned clearly, the amicable settlement or then move on to arbitration. That is the case. Thank you for those input. Let us move on to next question. Sectional completion or partial possession. The employer wants to occupy one wing of the building early. Advise the employer on the contractual difference between sectional completion and partial possession under the Red Book and the key consequence of each on LDs and the defects notification period. Anybody wants to try?
Can
Yes,
I
please.
try that?
Yes, please.
Okay. Sectional completion is sectional completion is usually predetermined, so it's agreed before contract signing, whereas partial possession is one where it's not predetermined. For example, maybe the employer sees that one part of the project, construction project, has been completed and they would like to use it with the permission of the of the contractor. They can have and use that as they wish, but only when the permission has been given, when the contractor agrees. When it comes to DNP period, the parts that have been sectionally completed and sectional possession, one thing is DNP period for those, for those areas will pretty much start at that period. And if the overall duration of the project was to be delayed, those parts of where has been completed will not have any liquidated damages for that. So liquidated damages will only be proportion to the extent of the rest of the project that is not in delay. So the full LDs will not apply within that period. So I'll advise the client in this case in this way.
Thank you for that. That is clear and concise. Of course, if we have some pre-planned things, the sectional completion, it provides the clearer mechanism. Otherwise, the engineer has to determine the fair and proportional reduction of LDs and defects notification period, announcement, all these things has to be determined. So thank you for that. Let us move on to next question. Determination. The employer decides to terminate the contract for contractor default. So this is particularly for persistent failure to proceed. He didn't proceed with the works even after repeated instructions or notices. Advise the employer on the precise contractual steps and notices required under subclass 15.2 termination by employer and the key financial risk if the procedure is flawed. Anybody wants to try? Here the employer is terminating the contract since the contract default, which is persistent
Yes.
failure to proceed. Please.
Yes, following the prior to termination to be sent the notice to correct to the subcontractor, and after that, if the contractor is not following the notice to correct, then to be followed the subclause 16.2 termination by the employer. So to be reviewed the ground of termination appropriately, and to be sent the notification to the contractor and provide the 14 days to the contractor to make the remedy of their default. In case within the 14 days the contractor is being not remedying of their default, then the second notice of the termination to be issued and to be terminated the employment of the contractor. The financial risks are to be consequences such as after termination of the contractor to be hired the new contractor. So that will require the additional time and additional cost also. And there could be a potential dispute risk between the contractor and employer. So these type of risks could be happen after termination of the contractor. So this will be my advice to employer.
Thank you for that. Anybody wants to add or further advice on financial risk of a flawed procedures? That means insufficient ground or those kind of thing. Okay, it's fine. So that is the procedure, usual procedure. We have to give notice of default, which is notice to correct after that is written notice for 14 days period. And then you have to give the second notice as a notice to terminate. This one will be there for a termination notice effective immediately. But the thing is, like if we are unable to justify later, maybe in the termination in UAE particularly may require court ratification. That time you have to justify them. So you have to have sufficient grounds and proper notices. Notices should not be referring to incorrect details. Those of the things are deemed to be wrongful termination or repudiation. So that has to be effectively dealt well ahead of the time. So all the serving the notices to be clear with appropriate justification. So that is the important thing. Thank you for that. Let us move on to next question. Final accounts. The contractor is late in submitting the draft final statement under class 14.11. Advise the engineer on the appropriate action and the subsequent mechanism for finalizing the payment under subclass 14.12 discharge. Because as you are aware, when it comes to the final, the contractor has to give discharge letter. That is very important. So in those kind of scenarios, if the contractor is delaying without submission, so what will be your course of action to the with the engineer? Anybody wants to try? Okay. So this is usually we have to issue the remainder notice if the contractor fails to submit the draft final statement within the required period of like 56 days in the FIDIC. After that, the final statement is due. The engineer is entitled under class 1.2 to determine the final amount due and issue the final payment certificate. Again, when it goes to the discharge letter, what is happening means he didn't respond to the notice. So automatically it is getting waived to the right to claim any further amount. That is what happening. So whatever is being certified, if the contractor is not responding to the remainder notice, then whatever is being determined by the engineer and certified, then it will be deemed to have waived the right to claim any further amount. That is the case as per the original FIDIC conditions of contract. If we are having something different in our bespoke or amended contract conditions, then that we have to specifically address. Thank you. Let us move on to next one. Liquidated delay damages. The project is completed 30 days late, attracting liquidated damages. Advise the employer on the maximum amount recoverable and the contractual prerequisite for leaving the damages under subclass 8.7 delay damages. Anybody wants to try? This is the standard procedure when the project is completed with the delay. Okay, so we have in the appendix to tender, there is a cap for the delay damages. So the maximum amount recoverable, usually it is capped by 10% as per the industry practice, and contractual prerequisite employer must have is issued notice of claim under class 2.5 employer's claim. It should have been issued to the contractor, followed by the engineer's determination under class 3.5, confirming the entitlement and quantum of the LD. So that has to be issued by the engineer. The employer can then deduct the determined amount from subsequent payments, subclass 8.7. The LDs must be a genuine pre-estimate of loss. So that is the case as per the standard FIDIC conditions. If deemed a penalty by a court, they may be unenforceable. Though this is legal risk, the employer should manage proactively. So that is the thing when it comes to applying LD. Let us move on to, anybody wants to add something? Okay, let us move on to next. I think we are end of the questions. Anybody having something to discuss or particularly wants to get clarified or having something in general we can discuss now?
I
Uh,
have
Yes,
a
please.
small doubt.
Yes.
Usually, if like I'm sitting for APC this time, so if the panel would ask me about the insurances, how you are verifying the insurances, like will it come under like ethics if I will try to answer that? Because as a QS, we are not supposed to review these insurances.
That's what. So whenever it is out of your area of practice, you never had experience to answer that question, you can clearly announce it to the panel that it is not the case that you have experience or first-hand knowledge by applying those things. And if you have some knowledge and understanding from like CPD activities or those things, you can announce again this is limited based on your knowledge gathering level only. It is not your experience.
Okay.
Okay. So That is the thing you have to do whenever something comes. It should not be there in your summary of experience. If you are hinting something in the summary of experience, then that will be the trouble. If it is not mentioned anywhere in your summary of experience, then it is fine.
Yeah. Okay.
Yes, sir. My question is usually general question. So whether, as I face already, the assessors are almost asking some question out of the submission. So what is the techniques to be used? For example, if they are going outside of the written submission, so are we having a right to stop them? So what strategy we will use, for example, to ask them to, this is being not part of my written submission.
No, you don't need to mention it is not part of your written submission. You can clarify. So, which is your scope of work or area of practice, or what limitations you have in your work experience? Those things you can explain it to your panel. So that is clear thing. But unless if they mention something that is there in your summary of experience, if you are clear that it is not there in your summary of experience, you can mention. In some of the cases, the candidate get confused and they forget, they mention something, but the panel say that it is there in your summary of experience, then it will be trouble. So that is the reason I used to advise all the candidates to read the submission repeatedly until you go to the APC. So if you are clear, you can announce it to the panel that your experience is limited and you don't have any first-hand experience on this, and you can ask the panel to move ahead. So they will present you with a different question or different examples from your experience. All they will ask a similar experience. If you had something from your own summary of experience, they will allow you to go ahead.
But sometimes they are preparing their own type of scenarios. This is the scenario-based question. So sometimes this is basically difficult to for the mind mapping, how they are asking the question and what is the purpose of the assessors to ask these type of scenario-based questions. So if they are asking the advisory level question on the scenario base, so if I will refuse to answer, so that is not my approach. So being they will consider it as a means disadvantage or
No. If it is
ahead.
not within your written submission and it is not in your area of practice, they cannot give you scenario-based questions. That is clearly the RSCS policy not to use some, what we can say, like a question bank like kind of things that they can bring something from the general practice. It should not be that. So always your written submissions are the basis for the questions. Maybe if you have something in your summary of experience, they may ask by extending it to further the knowledge or further the discussion. So those kind of things can be a situation like the employer agreed for something. Maybe if he didn't agree, what would happen? So those kind of scenario is allowed, but not the thing that is completely irrelevant to your area of practice. They are bringing something like you are working there and you are facing this situation, what you would do. So those kind of scenario based questions are not advised from RACS. So automatically, if some assessor, if they bring up something like that, you can clearly say, I'm not comfortable since I had no experience in that area. My experience are limited to these kind of things. We are not practicing that. We have separate department or designated person for that kind of activities. So we just coordinate and take their expert opinion and then finalize based on that. So those kind of things are allowed. So you can announce clearly. You have to be honest whenever you are presented with some of the experience that is not your own experience. So that is allowed. So it will not be taken as a, when you are clearly announcing to the panel, it will not be taken as a negative aspect or something. But if you don't, or trying to beat around bush, or trying to pause, or you say you will come back, or if you say something, then it will be on your account, and kept it as some negative feedback. So always you have to define, no, this is not my area of experience. You never had that thing, since your organization is practicing differently, or you have different authority level responsibility limitations, then that is fine.
Sir, sometimes we are
Yes,
asking,
please.
we saying we will come back to this question. If we are not aware about it, so we are saying I will come back to this question. So they are counting that particular question that we come back to this question on later stage. So they will count this question, the candidate will come to the question, or they will count it, candidate is unaware about this question. So
No. They
means
will keep it
is
until the last moment, when they will permit you 1 or 2 minutes, which is available before concluding. They will ask you if you want to come back, or if you want to get clarified. You may do that now. So that time, if you are not sure about the question, or you didn't get clearly what they were asking, you should try and get clarified, and confirm whether that is your area of practice, or you can answer something, or you have to clear it. If you don't clear it, you don't go back there, then automatically you are unaware of it, and it will be on the negative feedback.
okay, sir. Thank you very much. Thank you.
Welcome. So anybody having something, if you have nothing to discuss, we can call it as a day. Thank you so much for joining. All the best with your preparations, and best of luck.
Thank you so much, sir. Good night.
Thank you. Thank you. Good night.
Thank you. Thank you.
Welcome. Bye.